Can I make estate plans without my spouse? Sometimes I get calls where one spouse is ready to sit down with an estate planning attorney and put their affairs in order, while the other spouse is not sure just yet. It's either because they don't trust attorneys, or they don't want to spend the money, for example, or maybe they don't like talking about incapacity and death. So should you get an estate plan in place even if your spouse is not interested? And the answer is yes and no, or at least let's talk about it. You should absolutely get powers of attorney in place. That is financial and healthcare, and they will allow you to choose who you want to be in charge to make decisions for you if you become unable to do so, and who has control over your assets, again, if you're unable to make decisions, pay bills, and so on. Regardless if your spouse is the person listed within your power of attorney, you should still sit down and get something in writing, because the alternative is someone having to go to court and ask permission from the court to do whatever is necessary. And just to be specific, this would be in regard to your separate accounts or individual accounts. Let's say you may have bank accounts that may be solely in your name, or maybe the mortgage is just in your name, or whatever the situation may be. Some decisions your spouse can make, but not all. Certain medical decisions your spouse cannot make, and of course they may not be able to access your separate bank accounts. In regard to getting an estate plan in place for what should happen to your property, it can get tricky, especially for assets that are held in joint tenancy. I would strongly recommend that you get the spouse on the same page and you together decide and put in writing what should happen to those assets. Now, you can absolutely make provisions for, again, your personal, your individual, your separate property. For example, let's say you have inherited some mineral rights from your mom or grandma or something. You can absolutely have a transfer on death deed. You can even have a trust where you provide what should happen to those mineral interests or to any other real property that is your separate property and that should not affect your spouse's interest. It is worth mentioning that sometimes state law or even internal regulations that certain companies have may make it impossible or very hard to get an estate plan in place to provide for the distribution of some of the assets you may have, let's say a retirement account, if you're trying to exclude your spouse from your estate plan. So it's important that you fully understand the consequences of getting an estate plan in place when your spouse, your current living spouse, is not part of that process. Also have in mind that if you die first, your joint accounts would likely go to your surviving joint tenant, and that could have unintended consequences. Let's say you own a home with a second spouse, or you're both at the second marriage, and one person dies first, the other one becomes the sole owner. If there is no estate plan in place, it is likely that the first spouse's children may be automatically inherited just by the lack of planning. In conclusion, can I make estate plans without my spouse? You should absolutely get a power of attorney at least in place, maybe an advance directive or a live-in will. Absolutely address your separate property. In regards to joint tenancy, you may want to fully understand the consequences and the options. So talk to your spouse. If it's time, sit down with an estate planning attorney and put something in writing, because the lack of an estate plan will cost your family a lot more time and money than it would cost you now to get everything done according to your wishes. Please be sure to share this video if you know someone who may be interested in hearing its content. Watch our other educational videos. Thank you for watching.